talk a little bit about REOs. And I'm sure you guys are doing a few of those down here, right? In an REO transaction, the most important thing is the contract you're using. Now, if they're using, as some lenders will, use a standard car purchasing agreement, there's not much you have to worry about because you're really familiar with those. The problems develop when they have their own contract, one that they've had drafted by their attorney. In those contracts, you may find an indemnity agreement, which basically says, if I, the lender, get sued by whoever buys this property, for whatever reason, you agree that you're going to make me whole by reimbursing me anything that I have to pay, including attorney's fees, costs, and any damages. You want to be real leery of that type of a contract. Now, if that's the only contract that they're going to offer you to use, there's not much you can do if you want to continue in that transaction. But you're taking a tremendous risk by entering into one of those types of contracts. As we all know, the lender in an REO is exempt from the TDS. However, because the lender's exempt, that doesn't mean that you do not have to do your visual inspection of the property. Because if you read the statute that requires you to perform that visual inspection, it starts off by saying, the realtor shall. When you see shall in a statute, that means there's no excuse not to conform with that statute. So if you're in one of those transactions where the lender won't give you access to the property, what you need to do is write a letter to the lender telling him that you've been prohibited from completing your statutory duty. If you have any problem drafting those letters, for those of you that have CRES insurance, you can contact our legal group and we'll write the letter for you. But it just has to be a simple letter where you're telling them you're prohibited from completing your inspection. The other thing you want to make sure you have in a REO property is a home inspection by I'm going to use the word professional home inspector. Now, nobody in California licenses home inspectors. So anybody with a pickup truck, a ladder, and a flashlight can be a home inspector. So what you want to use in home inspections, especially on REOs, is someone who's a member of either CREA or ASHI, or there's some third group now that started up called NABI or NIBI or something like that. But the reason you want to use, let's say, a CREA inspector is that they have to have continuing education and they have to take tests during the year to keep their membership in that organization. And in 1998, there was a set of statutes that were passed in the Civil Code that provides professionalism to home inspectors since nobody will license them. So that's why you want to use a CREA or an ASHI inspector. On the title report on an REO, it's important to have the easements, if they exist on the property, plotted by the title company. And they'll do this. Title companies perform this service for you. Once you have that plot diagram or the easements plotted on the property, you want to make sure you have a signed copy of that from the buyer, buyer's signature on it showing that they received it. Because it isn't your duty to do anything more than provide that plotted easement. You don't have to get a meets and bounds description. You don't have to go out and stake out the easement. All you need to do is make sure the buyer has a plotted easement map so that he or she knows that there's an easement and here's where it is. And if they need to go further, that's their responsibility. So in REOs, that's really the three main things we have to really worry about. The rest of general things that can happen are mostly contractual, and you're not really a party to that contract. So, does anybody have any questions about REOs or anything they want to discuss about? Yeah.
When you have a home inspection or an REO, what's your experience or your advice when there's no electricity or gas and your home inspector doesn't have access to that?
That's a common, they ever hear that question? Okay, that's a common thing that'll happen, is the lender will not turn on the gas or the water or the electricity. If the home inspector calls out that they couldn't check the dishwasher because the power was off or the water was off, as long as that's in the report, you don't really have any liability for that. Because it's in the report, it goes to the buyer knows it. You can work with a lender to see if they will turn it on. Some will, but they have some kind of arrangement, I believe, with most utility companies now, where they can turn it on for a period of 5 hours on one day, if they want. So ask the lender to do it. If the lender says, no, we're not going to do it, make sure the home inspector notes or tell the home inspector, we don't know if there's any power here, we don't know if the gas is on, we don't know if the water's on. If they'll put that in the report, then the buyer has it.